Peace to Yahuwah, peace to Yahuwah. How y'all doing tonight? Hope everyone is doing wonderful, magnificent, and great. I know I am. Second, shit was a little fuzzy. I know I am. Peace to Yahuwah. Welcome to the Jonah Bey Show, where I go in on law. I also do a segment later on where y'all can ask me questions in the whole nine. Man, I cleaned out my pool, and I'm about to coat it, and then I'm about to fill it. But the problem is, man, I released 1 billion mosquitoes when I cleaned it out. 1 billion mosquitoes. So I'm about to open up the pool. That's what I've been working on at home. In the whole nine. I worked on the front yard so well, I forgot to work on the backyard. The grass is suffering. I hope it comes back, because if not, I'm going to have to resod the backyard again next year. But anyway, I was talking to a brother and his client. They went to court today with the bank. And of course they won. Testimony. Hopefully they'll get on later on and tell y'all the testimony. They had to go to mediation. The woman said, I ain't making no deal. Y'all in the wrong. Forget mediation. So then the mediator took it back to court. So when they went back to court, the bank dismissed the case, right? So the bank said, I think they said with prejudice or without prejudice. I can't remember which one. Anyway, it's the one where the bank could bring the case back if they wanted. And then they asked, well, you got a counterclaim. Are you going to dismiss your case, or are we going to go to trial with it? She says, nah, I'll dismiss the case and wait and can bring it back whenever I can, right? So I said, oh, okay, that's cool, because now you can learn how to sue them and win now. So I said I would do a show today to help them and y'all to win that case. Now, the law that we're going to be discussing tonight, I discussed it maybe a month and a half ago, maybe two, but let me reiterate it because they need that law now. And it's called OCGA 11-3-309, which is enforcement of a lost, destroyed, or stolen instrument. What I gotta say is, see, the banks hate because they have no defense for it. If you say that you claim the original contract was altered, stolen, and then you say you can say that because you're the only one that has firsthand knowledge. You're the only one that was there, right? You're the only one who signed. The original instrument, whether it's a mortgage note, a card note, a credit card, it was altered and stolen. Mute out. What the hell's the matter with you? Ben, mute out. What the fuck the matter with you? I can't stand that. They come in with their mic open. Why? No one wants to hear you. This ain't time for y'all to be asking questions. Right? So they can't stand. So anytime you're dealing with a bank, whether it's a foreclosure, whatever, you're supposed to say you will claim that the original contract and records was altered, stolen, and then they have to bring that contract in to prove that it wasn't altered or stolen. But I'm going to keep it real with you. They all been altered and stolen. Why? It was stolen from you because you are actually the one that is lending money to the bank because you give them a security. Even if you do an application, that's a security. You're giving the bank the money. They deposit it, get the money from the Federal Reserve Bank, so you gave them a loan. Now, let's make it in conjunction with the law that I'm talking about, which is OCGA 11-3-309. Enforcement of a lost and destroyed or stolen instrument. A person not in possession of an instrument is entitled to enforce the instrument if I, the person was in possession of the instrument and entitled to enforce it when loss of possession occurred. So what they're saying is this third-party debt collector would have had to have the actual instrument in their possession, and then they lost it. Then they would have the right to try to collect on it. But you know, a third-party debt collector, 10 years ago, 15 years ago, you got your house. Of course, they don't have the instrument. Number one, they could never have the instrument because before you closed on the house, they altered that instrument and got paid for it. No one has the instrument. No one has the note, the promissory note, the application. No one has that. No bank. All right? Let me go on. The loss of possession was not the result of a transfer by the person or a lawful seizure. So they can't, the note couldn't have been seized or anything, right? The person cannot reasonably obtain possession of the instrument because the instrument was destroyed. So they can't come after you if the instrument was destroyed, right? Its whereabouts cannot be determined, which means it was lost. They still can't come after you. Or it is in the wrongful possession of an unknown person or persons that cannot be found or is not amendable to service of process. So basically, no one else can have the note, because if someone else has the note, and let's say you pay this person, this third party, whoever has the note can come after you again and try to make you pay the same damn bill. So that's a no go. No Brenano. No go. You know what I mean? They can't come after you. This is according to the note. Now let's read part B. This is why they have to have the note. Right? Because they can't enforce it if they don't have it. They don't have the right to enforce it if they don't have it. The note or the actual application. You got to bring that up. You got to know what you're talking about. You got to use this law right here to state your claim, right? Okay, B. A person seeking enforcement of an instrument under subsection A of this code section must prove the terms of the instrument and the person's right to enforce the instrument. Now, did you hear what it just said? What I just told you. They have to have the instrument to have the right to enforce it. I know y'all heard this before, but here's the law telling you that. The law is literally telling you they have to have the instrument to be able to enforce it. Then it says, if that proof is made, Code Section 11-3-308 applies to the case, as if the person seeking enforcement had produced the instrument. Then it says, The court may not enter judgment in favor of the person seeking enforcement unless it finds that the person required to pay the instrument is adequately protected against loss that might occur by reason of a claim by another person to enforce. The instrument adequate protection may be provided by a reasonable means. So it's saying when you write your defense, you got to say they must produce the instrument to prove that they have the right to enforce the instrument, and they must produce the instrument to prove that no one else can come after me for this same debt. This is what your paperwork must say. And add on what I said to you earlier, that you swear that the original note, contract, or records was altered and stolen. I can show you a mortgage for one of my houses, right? On it, it says paid to the order of, without recourse. I assure you, it wasn't on the note when I signed it. That's altered. All notes and securities is going to be altered like that. Every last one of them. It's in 31 CFR. That's how they get paid for it. So you must bring up these topics with this law. So if the brother want to help his client go in and sue the bank now that they got the case dismissed, they still bring up those same subjects. That you want to sue them because they never had the original note, which meant that they never had the right to enforce the note, which also says that the note was altered and changed, which means the note was forged and stolen. Right? That's your defense to it. This is how you shut them banks down. Now, we've used it several times. Several times. I even used it for a case with my wife. Same thing. Dismiss, won. Now it's time to start going after them for money, for even bringing you in court, when they know they never had the right to come after you, to pay you for the time you had to use to defend the case, to pay you for the time you had to miss work, to pay you for the paper and the ink you used to defend it, plus your time. I hope y'all are understanding it. I'm trying to go slow. I'm trying to make y'all understand it. Y'all have the power. Y'all have the laws that they must follow. I give it to y'all. Will you know how to apply it properly? So I'm going to go to the call lines and see if they there, if I can get that testimony real quick. No, I don't see him. Marlon.
Rich woman.
Rich woman? Okay.
It's rich woman.
Peace to Yahuwah.
Hey, peace. Hello, family. My name is Sharon. I went to court today. I'm actually Marlon's mom.
I wasn't going to tell him you was Marlon's mom. Okay.
Well, he's an equal butt kicker because he kind of kicked me in the pants every so often. And
it's all for love and for you to get your remedy.
Yes, absolutely. And you know, and I'm happy that he allows me to hang around on the team. he's the pacekeeper, and I'm just trying to keep up.
Right.
So
yeah, let me ask you. You went to mediation. What was that like when you went to the judge? Was like, y'all go to mediation.
Well, actually, we didn't go to mediation today.
I know you went the other time, right? What was that like?
Well, when we went in, I asked the opposing attorney how come he hadn't answered any of the paperwork that I put in.
What lie did he tell you?
That he didn't have to, and he don't have to answer that, and that's not what we were there for.
Didn't he say something about he don't have to answer discovery because this ain't a criminal case or something like that?
Yes.
Yeah,
yes,
he
absolutely.
lied.
That is what he said to me, and he.
So
was,
I wanted to bring out.
I
wanted to bring out the type of lies they're gonna tell people. So go ahead.
And he was, to me, he was disrespectful. He was 15 minutes late. He looked as if he had been playing racquetball. A tall white guy. I mean, his underpants was showing, and he barely even looked at me, as if he was dismissing me.
Mm-hmm.
And that didn't sit well with me. And he was like, I don't have to answer that. As if, he was above the law. He doesn't have to answer me. And so I just went ahead and said that, well, we're not going to come to an agreement, because what his actions were was pushing his paperwork across the table to find out if I want to settle or make some type of payment arrangements, and they'd be willing to work with me on that. And I didn't even entertain the paperwork. I just looked at it on the table.
What my wife did, she wrote a letter to the mediator and said, I'm not settling, I'm not paying nothing. If anything, they must pay me. They haven't produced the original contract, and they haven't answered my discovery. And that's what she wrote. And when she went into mediation this week, that's what she said to their face. Mediation, I got the audio. I probably should have prepared it to play it on the air, but no worries. And she was in and out of mediation in about 3 minutes. And they said, the mediator said, he was complimenting her on her English accent and all that. And then he was like, he's gonna bound it back to the court.
Yeah. Well, she had me beat because mine was 6 minutes, hers was 3.
Right.
So she was more efficient.
Yeah. So we went past mediation. Now we went to court. They put it back in the court. So what happened today?
Okay. Yes. So it started with our strategy. Most of you know that I was in the hospital for asthma. And so they actually sent me home with oxygen, which is not, they said that's not normal, but they felt as if I needed it. So Marlon said to me, he said, Mom, I want you to go to court, and I want you to be an old lady, a defenseless old lady. And I was like, I am looking a little bit old these days. He said, no, don't dress the way you like to dress going places. I want you to be a defenseless grandma. And I'm thinking like, okay, you want me to actually leave out the house like that? He's like, yes.
So he wanted you to basically to give people an image. He wanted you to go in there and look like a little old Christian old lady in the church.
Yes. Defenseless, sick, and this company's beating up on me. Those were his words. So
put on a gray wig and all.
Well, no, I wear my own hair, and I just did a wash and wear, so it was curly. It was a small, curly, kind of tapered afro, and I wore no makeup at all. I wore a long blue jean skirt.
Was the gray showing?
Yeah.
Was any gray showing?
Oh yeah.
Okay.
I've got gray hair.
Okay.
Mm-hmm. Yeah, I'm al natural. I cut out all the gray out of my hair. It was about shoulder length, and I just cut it all off. So I cut out all the color, and so yeah, I'm gray. And I put on a nice linen top, but then I put on a cardigan over it, as older people might do.
Man, you sound like a school teacher. You sound like a Jehovah's Witness that come to your door preaching Jehovah.
Yes, knocking on doors. And I actually had on a nice little pair of like flats, and I took those off and I put on my sneakers, my on cloud.
Uh-huh.
Now, all of this is totally not me. And I looked at, I said, oh, Marlon's going to be so proud of me. I put the oxygen in my nose. I had the compression.
Oh my God, you walked in with the oxygen in your nose?
I did.
Oh, they trying to beat, the big old bank is trying to beat up on this poor defenseless old woman. I can picture it perfectly.
And I was walking, and I walked pretty, lively. So no, he said, "Take your time, Mom," and I said,
"Act like you could barely walk."
I got to the courtroom, and the bailiff started helping me. Well, let me help you, Mom. I had to plug it in into the outlet because the oxygen only lasts for so long when you're just using the battery.
Right.
And he helped me, and I was like, "Oh, thank you, baby." And he said, we got to look out for each other. I'm praying for you. And I was like, "Oh, thank you, sweetheart."
This is great.
And the judge wanted me to, she was like, "I can't hear you," because I had to sit further in the back because that's where the outlet was. And then so I said, I could come up front. And I went up front, and then that's when she started asking me. She said that the plaintiff wanted to dismiss the case. And she said, "You have a counterclaim, don't you?" And I said, "Yes, I do have a counterclaim." She said, "Well, they want to dismiss without prejudice." And I'm fumbling around and I'm thinking, because I was already, Marlon had gotten me ready for Trinsley versus Pagliaro and objecting and all of that. I was ready there, but that was a curveball. And I needed a second to think. And I said, "Hold on, wait a minute." And so she gave me a minute while I gathered my thoughts. And I said, "Is that with prejudice they want to dismiss?" And she said, "No, without." I said, "So does that mean that they get to come back later if they choose to?" And she said, "Yes." She said, "But you can move forward with your counterclaim, or you could dismiss it without prejudice as well. But if you go forward and you lose, then you can't come back, but they can still come back after you." I said, "Well, I'm going to dismiss it the same way they're doing, without prejudice, because I'm going to come back at them as well. If, the same thing you're giving them, I want to have those same rights."
Right.
And so we both agreed on that, and so that was it. That was the end, pretty much.
Good. So everyone dismissed their case, and you walked out, and you don't have to pay that money. And you saved.
That is correct.
And you saved a couple of $1,000s that you don't have to pay.
That's correct. $1,800.
Well, congrats. Keep up the good work. And
I thank you for allowing me to give a testimony, because I definitely want to let everybody know that Jonah Bey shit don't work. And it's great to be on a team that